Okay, so we are continuing with Library's opposition to Wayfarer's Dalbert motion to exclude the testimony of Jeffrey Kinrich. Kinrich is her brand expert, I believe. I have just recorded a video. If you haven't seen it, we've had an order where Judge Lyman has basically set out, how much time each party gets to sort of present arguments for specific elements of the Dalbert motions, bifurcation, and some other sort of preliminary sort of trial details. It's well worth going and watch that video. It's not a long video, but it's got all the information on what tomorrow's hearing is likely to look like. And I will be doing a video on that after it is a face-to-face hearing, so I'll be taking the I'll be taking the X posts from Matthew at Docket Updates, who is a court reporter who has special permission to kind of tweet and use media in these hearings, which are normally closed. And when I say closed, I mean that you can't take your devices in there. You can go in person, but you can't take devices. All right, so Jeffrey Kinrich. In August 2024, as part of their plan to retaliate against Miss Lively proposing a hostile work environment created by the Wayfarer parties, defendants devised a scheme to attack her as insensitive and tone deaf. Oh my god. I cannot believe this is the bar that we have come to now. How devastating, insensitive and tone deaf. Defendants devised a scheme to attack her as insensitive and tone deaf for promoting her hair care brand, Blake Brown, and her beverage brand, Betty Booze, while starring in a movie about domestic violence. And I've already pointed this out in previous video. This I don't love, right? She is trying to separate the act of promoting her brand with the fact that she was starring in a film about domestic violence, which, if you listen to her other interviews, it wasn't about domestic violence, according to Blake Lively. So these things are not separate, and that is what upset people, right? But she's trying to pretend that they are. They're not. She cross-promoted her brand and basically completely upended the entire planned marketing of the movie, which was to focus on, try and focus on the DB aspect, amongst other things. But she made it all florals and, theme parties and shit so that it would fit with girly products such as hair care stuff that, doesn't have conditioner, and fruity cocktails and mocktails. I gotta laugh at this as well, just because this is just sensationalism at its finest. Defendants plotting to bring in the fact that she promoted a hair care line and her own drink brand as part of promo. She did, and it is relevant. Something is redacted. The financial impact of defendants' misconduct on Miss Lively's interest in these companies was swift and devastating. After 7 years of development, but only 4 days of launch, Blake Brown, which had launched in August 2024 and initially defied projections by generating sales of more than $7 million in its $7 million in its first month, saw sales decline dramatically to just $374,000 to $462,000 a week by September. It's because people realized how shit it was. Likewise, after 3 years of development, by the end of 2024, Betty Booze was generating only a third of the revenue it had been generating prior to defendants' online manipulation. In a matter of weeks, Miss Lively saw years of her time and financial investment erased. I don't think she quite gets this, right? If people don't like someone, they tend to boycott the products too and boycott the films. It's like us. We're now like, oh, I'm not watching anything by Blake Lively or Ryan Reynolds after watching all the shit that they've pulled. That's how it goes. I'm not going to spend money on Blake Brown Beauty, and I'm not going to spend money on Betty Buzz. And I'm not going to buy aviation gin. I would never, if I was in America, I would not have a plan with Mint Mobile. That's what happens when you piss people off. They don't just sit quiet and continue to buy your crap. They boycott it. It's called a protest. And what this woman, right, she's not got the message, and she thinks none of this is her fault, and everything has to be someone else's fault. Defendants now seek to exclude evidence of the millions of dollars in financial harm they caused by shutting out the opinion of Miss Lively's damages expert, Jeffrey Kinrich. The court should deny these efforts, and probably will. Yeah, I think they'll let him testify. To be clear, defendants do not attack Mr. Kinrich's credentials, qualifications, or his methodology, nor could they. This is a guy who didn't he work at the same place as Michael Wagner, the Wayfarer rebuttal expert? Mr. Kinrich is a certified public accountant with more than 40 years' experience analysing damages in commercial disputes, who has testified in approximately 100 cases since 2017. He uses the well-regarded discounted cash flow method to reach his damages calculations, a methodology that redacted. Instead, defendants resort to technicalities and argue, as they did in Motion in Limine number 17, that Miss Lively lacks standing to seek lost profits damages suffered by Family Hive, which owns Blake Brown, and Betty B, which owns Betty Booze, together with Family Hive, because she holds her interest in the companies through a holding company, Lol Hatter. These are red herrings. Mr. Kinrich calculated Miss Lively's economic damages based on the reduced value of her share in the companies as a result of their lost profits. Under the DCF method, the amount of the reduced value in her interest is the same. However, that interest is held whether Miss Lively received distributions or not. The court should reject defendant's attempt to deny Miss Lively her day in court based on corporate formalities that have no bearing on the ultimate value of her economic damages. Moreover, even if the court were to find that Miss Lively lacks standing to seek lost profits, evidence of Mr. Kinrich's opinion should nonetheless be admitted to guide the jury in determining the value of her non-economic damages for reputational harm. The court should also reject defendant's argument that Mr. Kinrich's opinion should be excluded as overly speculative. Contrary to defendant's suggestions, there is no per se rule precluding a new business from recovering lost profits. These cases defendants rely on are inapposite because they involve business ventures that never even came into fruition, making the very existence of those profits far too tenuous for any expert opinion to have foundation. I mean, they are literally claiming lost profits for a company that was launched 4 days before the premiere, and which was losing profits after 1 month, according to Lively. So, I mean, I feel like, Wayfarer made a stronger argument. That is not the case here. While Blake Brown and Betty Booze were newer ventures, they entered the market and performed long enough to allow Mr. Kinrich to verify the reasonableness of company-endorsed projections. Projections that, in the case of Blake Brown, were actually outperformed by real-world sales. In the case of Betty Booze, the product was on the market for over a year, and Mr. Kinrich relied on projections prepared in the ordinary course of business by an experienced management team to conduct his calculations. Although defendants claim otherwise, Mr. Kinrich describes in his report all of the steps he took to independently verify and test the assumptions underlying those predictions. All defendants' other complaints are appropriate subjects of cross-examination, not bases for exclusion. For these reasons, Mr. Kinrich's opinion satisfies the requirements of Federal Rules of Evidence 702, and defendant's motion should be denied. Mr. Kinrich's opinion calculates Miss Lively's economic losses under various scenarios. Mr. Kinrich calculates the economic damages suffered by Miss Lively based on her proportional ownership interest in the companies. To perform this calculation, Mr. Kinrich used the DCF method to first determine the but-for profits of Family Hive and Betty B. Each company would have made but for defendant's misconduct. And then subtracted, I'm going to read that again. To perform this calculation, Mr. Kinrich used the DCF method to first determine the but-for profits of Family Hive and Betty B, and then subtracted their actual profits from the but-for calculation. I didn't see the bracket. He then multiplied that number by Miss Lively's ownership percentage in each company through lol hatter to calculate the economic harm to Miss Lively's interest based on the company's lost profits. For Blake Brown, Mr. Kinrich also calculated the lost royalties Miss Lively would have earned from Blake Brown but for defendant's retaliation. Defendants characterized Mr. Kinrich's damages opinion as falling between $39,600,000 and $143,500,000. I still don't know how you get to that. That's got to include Ryan Reynolds' reputational harm and damage to brands and all that crap. She's not even been worth the lowest number there ever. In 20 years, she's never been worth nearly 40 million. 30, maybe. Defendants characterize his damages opinion as falling between those two numbers to suggest that Mr. Kinrich gave himself an absurdly wide margin of error. Yes, over $100 billion. That is misleading. The range is the result of Mr. Kinrich's calculating specific damages numbers under multiple scenarios, all of which he explains and supports. Well, this I can't wait to read. 1. For Blake Brown, he estimated the economic damages to Miss Lively's interest to be $45.1 million in a scenario where the brand ultimately never recovers, the shutdown case. And B, $19.4 million in a scenario where the brand recovers after a planned marketing investment, the marketing investment case. For Betty Booze, he estimated the economic damages to Miss Lively's interest to be $28.3 million in a shutdown case, or B, $7.9 million if the company were to recover to a pre-retaliation level within 2 years of the retaliation, the 2-year delay case, and C, $11.2 million if the company were to recover within 3 years of the retaliation. Then 3, for Miss Lively's lost royalties from Blake Brown, he estimated these losses to be $70.2 million in a shutdown case, and B, $12.3 million in the marketing investment case. Okay, so economic damages for Blake Brown is number 1, and then lost royalties is 3. Yeah, and they are different. Experts are permitted to calculate damages to account for multiple scenarios, and the difference in range created by these varying scenarios is not grounds for exclusion. When totaling Mr. Kinrich's damages calculations within each corresponding scenario, the lower scenario assumes the marketing investment case for Blake Brown and the 2-year delay case for Betty B, for a total damages amount of 39.6. The higher scenario assumes a shutdown case for both companies for a total damages amount of $143.6 million. These different scenarios account for Mr. Kinrich's range, not a margin of error. Mr. Kinrich's expert opinion is admissible and relevant to prove damages suffered directly by Miss Lively, whether economic or non-economic. Defendants repeat their argument that Miss Lively lacks standing to pursue damages for her retaliation, aiding and abetting, and breach of contract claims, the same argument defendants made in motion in limine number 17. As set forth in Miss Lively's opposition to motion in limine number 17, which she incorporates here by reference, defendants' standing argument is meritless. In short, defendants have cited exclusively to cases where the individual plaintiffs were held to lack standing, because they had not alleged any individual injuries and were seeking lost profits for legal injuries that had been directed at a company or some other third party. In contrast here, Ms. Lively has alleged claims for employment retaliation under FEHA, the aiding and abetting of that retaliation, and the breach of a contract that prohibited such retaliation. The alleged injury, retaliation for objecting to a hostile work environment, was directed at Miss Lively, not the companies. Miss Lively was not required to bring these claims derivatively on behalf of the companies, nor would it have been possible for her to do so, as the companies were not the ones who suffered employment retaliation. California law permits Miss Lively to seek any economic damages caused by defendant's retaliation as compensatory damages under FEHA and as special damages for breach of contract, and she is thus entitled to seek the full panoply of damages necessary to make her whole, including her interest in any lost profits. Mr. Kinrich's opinion is admissible and relevant to prove the amount of those economic damages. Even if the court were to hold that Miss Lively lacks standing to seek lost profits, she is separately entitled to seek non-economic damages for reputational harm. Blake Brown and Betty Booz were businesses built on Miss Lively's reputation and image. The lost profits of these ventures caused by attacks on Miss Lively are direct evidence of the value her reputation brought these brands. Such evidence is independently admissible to assist the jury in ascertaining the severity and real-world value of Miss Lively's reputational harm, which would otherwise be difficult to quantify. The court should disregard defendants' fixation on whether any profit distributions would ultimately have flowed to Miss Lively. Defendant's argument fundamentally misconstrues Mr. Kinrich's opinion and the basic principles of economic damages. Defendants appear to be under the misimpression that Miss Lively has made a claim for lost distributions. That is incorrect. Mr. Kinrich used the DCF method to calculate the economic damages associated with the reduction in the value to Miss Lively's ownership interest in Blake Brown and Betty Booz based on the lost profits calculation of those businesses. Whether Miss Lively was harmed because her portion of any potential lost profit distributions was reduced, or whether she was harmed because the value of her ownership interest in Blake Brown and Betty Booz was diminished, the method of calculating the amount of that harm is the same, the DCF method. It is well established in both case law and the principles of corporate finance that the DCF method is one of the most reliable ways to calculate both lost profits and the value of a business interest. Because the measure is the same, it is immaterial whether Miss Lively suffered the loss in the form of a reduced cash distributions or simply in the diminishment of the value of her ownership interest. Both are subject to the same DCF calculation, and the amount of the economic loss is ultimately the same. Mr. Kinrich's analysis of economic loss does not depend on whether any particular amount would have been distributed to Miss Lively, because distributions are merely one possible way business value may be realized. Mr. Kinrich's lost profits analysis is thus a way to measure the loss associated with Miss Lively's ownership interest in Blake Brown and Betty by assessing the business's lost profits in a but-for world where defendants did not retaliate against Miss Lively, and the actual world in which they did. This analysis does not rely in any way on actual distributions being made to Miss Lively or anyone else. As a separate matter, defendants' hair-splitting arguments regarding standing and distributions have no application to Mr. Kinrich's opinion as to Miss Lively's lost royalties, which are based on net revenues, not profits. As explained by Mr. Kinrich, Miss Lively is redacted. Miss Lively redacted. Thus, even if defendants' standing and distribution arguments had any merit, they do not. They would have no bearing on Miss Lively's royalty damages. Mr. Kinrich's lost profits opinion is not speculative and is based on sufficient facts and data. Defendants next argue that Mr. Kinrich's lost profits opinion must be excluded as too speculative because Blake Brown and Betty Booz are early-stage business ventures, to the extent that defendants contend that lost profits are not available to newer businesses. They are wrong. There is not a per se rule forbidding the award of lost profits damages to new businesses, but rather an evidentiary rule that creates a higher level of proof needed to achieve reasonable certainty as to the amount of damages. Courts recognize that any calculation of damages based on lost profits always entails a degree of uncertainty caused by the need to rely on assumptions and estimates. But the mere fact that a party disagrees with the methodology utilized or a particular assumption does not render proof speculative. Ultimately, whether the claim involves an established business or a new business, the test remains the same, i.e., whether future profits can be calculated with reasonable certainty. Reasonable certainty does not require lost profits to be calculated with mathematical precision. It is enough for the plaintiff to demonstrate a reasonable probability that profits would have been earned except for the defendant's conduct. It is the jury's role to determine the probabilities as to whether damages are reasonably certain to occur in any particular case. Courts have admitted expert opinions on lost profits for early-stage businesses where the experts base their opinions on reliable information such as sales data of comparable companies, the input of the company's experienced marketing team, and the existence of a known customer base. Mr. Kinrich's lost profits analysis more than meets the standard. Mr. Kinrich relied on contemporaneous company forecasts and materials prep in the ordinary course of business and verified them through interviews with company management, independent analysis of market trends, a review of similar products, the existence of a large social media presence, and actual sales data. These are precisely the kinds of independent verification methods courts have held make lost profits opinions for newer businesses admissible. Defendants fault Mr. Kinrich for 1. Relying on company-endorsed projections that defendants claim he failed to independently validate, and 2. Failing to consider a series of argumentative, hypothetical, alternative causes for the company's decline. Neither of those arguments is a basis for exclusion. Mr. Kinrich was right to rely on company-endorsed projections, and defendants' various critiques of the assumptions and alternative reasons he considered all go to the weight of Mr. Kinrich's opinions, not the admissibility. Mr. Kinrich relied on projections prepared in the ordinary course of business, which are considered presumptively reliable. Defendants curiously criticized Mr. Kinrich for relying on projections that were created in the ordinary course of business by the companies or at their direction, complaining that such forecasts are nothing more than an entrepreneur's cheerful prognostication. Far from being optimistic prognostications, the forecasts are professional projections based on detailed data and analysis that Mr. Kinrich independently corroborated through market research and review of actual sales figures. For Blake Brown, Mr. Kinrich relied on an extensive July 2023 forecast prepared by Deloitte, one of the most reputable accounting firms in the world. As a footnote, it's heavily redacted, but it starts with defendants misleadingly suggest. So I'm curious to see what it says under there. Mr. Kinrich relied on financial projections prepared by Betty B's experienced management team in October 2024 in the ordinary course of business. In both cases, Mr. Kinrich confirmed that management respectively had reviewed and agreed with the forecasts. For Blake Brown, he confirmed that redacted. It is well settled that the use of management projections is presumptively appropriate, especially when they were made in the ordinary course of business. Defendants fault Mr. Kinrich for relying on a third-party forecast for Blake Brown, while simultaneously faulting him for relying on a management-prepared forecast for Betty Booz. Defendants are wrong to suggest that reliance on either kind of information supports exclusion. Courts in this circuit have consistently allowed the testimony of experts relying on internal company data on the ground that any issues with the underlying data goes only to the weight that it should be afforded their testimony, but not its reliability. At the same time, courts also recognize that an expert may rely on data that she did not personally collect. That expert used projections prepared by another party does not render her opinions based on those projections inadmissible. Mr. Kinrich independently verified the projections. Mr. Kinrich's report sets forth the extensive steps he took to independently verify the forecast before deciding to rely on them. Mr. Kinrich first evaluated the company's financial documents to ensure they were accurate and consistent with market data. For Betty Booz, Mr. Kinrich confirmed that the assumptions used in the Betty Booz forecast are consistent with contemporaneous evidence. As Mr. Kinrich explains, Betty B's projections were based on an expected performance through 4 distribution channels. 1. New innovations. 2. Reorders. 3. The brand's partnership with Princess Cruises. And 4. Internal markets. Mr. Kinrich conducted his own independent market research to confirm that the forecasted growth through these channels was consistent with growth achieved by other brands in the RTD alcohol market, including analogous celebrity-backed alcoholic drinks. Mr. Kinrich also compared the Betty Booz forecast to the historical sales numbers of comparable ready-to-drink brands such as Mom Water and Carbless, and concluded that the Betty Booz projections were in line with the experience of the other recent RTD entrants. Kinrich then considered Betty Booz's actual sales performance and distribution history over the course of its year on the market, including that it had expanded to more than 5,000 accounts across major national retailers as of August 2024, exceeding the internal forecast for 4,800 accounts. He also reviewed Betty Boo's social media following, confirming that it ranked second among RTD brands with a social media following, behind only White Claw, as well as observing that Miss Lively and Betty Buzz had combined following of 46 million followers. Finally, Mr. Kinrich confirmed that Betty B's management had substantial experience building and scaling celebrity-owned alcoholic brands, including Sombra Mezcal and Aviation Gin. There we go. Demonstrating a proven track record of taking emerging alcohol brands to significant sale. For all of these reasons, Mr. Kinrich concluded that Betty B's internal forecast for growth was reasonable. For Blake Brown, Mr. Kinrich explains, redacted. To verify the reasonableness of Deloitte's forecast, Mr. Kinrich conducted third-party market research to confirm Deloitte's assumptions about anticipated consumer behavior with respect to beauty products and prestige hair care brands, including by reviewing survey findings. Mr. Kinrich further corroborated Deloitte's conclusions about Blake Brown's growth potential by reviewing comparable sales figures for similar prestige brands. Mr. Kinrich also reviewed Deloitte's benchmarking based on industry analysis of 1. Comparable public companies, 2. Private acquisitions, and 3. Venture financings, and confirmed that their forecast assumptions aligned with observed market transactions. Mr. Kinrich also reviewed the deposition testimony of Family Hive's management to confirm that the forecast was in line with real-world company data, and conducted further verification of those facts by interviewing Family Hive management himself. Importantly, Mr. Kinrich's reliance on Deloitte's forecast was grounded in Blake Brown's actual sales at target, which ultimately exceeded the forecast's most aggressive projections, making defendants nitpicking about the basis for productivity level assumptions irrelevant and further corroborating the forecast's reliability. Do you know something's redacted? And I do wonder, though, right? This is just me again thinking out loud. I wonder how well her brands would have performed had she not piggybacked her marketing and promotion of them onto the film at Wayfarer's expense. I would love someone to ask this guy that question. The cases cited by defendants are distinguishable because they involve new ventures that never existed. The cases defendants rely on that reject expert reliance on so-called cheerful prognostications are distinguishable in that they all involve businesses that never launched at all and did not rely on any actual sales data. Moreover, many of the new business ventures at issue in those cases depended on wildly uncertain variables before a single dollar in profits could be generated. For example, in Schonfeld, the plaintiff needed to secure $44 million in financing to launch the hypothetical news channel. In Kenford, for the parties to perform pursuant to a stadium operating agreement, the stadium first needed to be constructed. In Imara's bio, for a new medication to hit the market, it needed to survive several clinical trials and obtain FDA approval. Similar uncertainties did not exist here. Blake Brown and Betty Boo's products were already post-development. Blake Brown redacted. Betty Boo's was not aspiring to be in 5,000 retailer accounts. It had those accounts, and the number exceeded projections. The facts here are thus more akin to those in Ashland Management Inc., where the court held a lost profits award for a new investment model was not speculative because it was based on evidence of the parties' carefully studied professional judgment on estimates, an existing customer base from the company's other products, and past success in the field. Similarly, Miss Lively's losses associated are rooted in detailed financial projections prepared by experienced business leaders, as corroborated by industry data and actual sales figures. Mr. Kinrich's reliance on these forecasts was thus reliable. As to defendants' complaints that Mr. Kinrich relied on a working capital forecast prepared by a shareholder for Family Hive or a presentation prepared by a third party for the company's performance, again, these are areas for cross-examination, not exclusion. That said, defendants admit the fact that the redacted. Defendants also omit Family Hive's CEO's testimony, which Mr. Kinrich reviewed, redacted. Mr. Kinrich considered and ruled out alternative causes. Defendants next claim that Mr. Kinrich's opinions must be excluded because he failed to consider every possible alternative cause for Miss Lively's damages. This is not grounds for exclusion. Even according to defendant's own authority, an expert need not rule out every potential cause in order to satisfy Dalbert. The expert need only address obvious alternative causes and provide a reasonable explanation for dismissing specific alternate factors. Mr. Kinrich has met that standard here. First, defendants ignore that Mr. Kinrich did rule out alternative explanations. When calculating the economic damages for Miss Lively's interest in Betty B, Mr. Kinrich determined that any decline in sales for the Betty Buzz product was due to facts unrelated to the online manipulation conduct. Mr. Kinrich then excluded the Betty Buzz product line from his economic damages calculation. In other words, the scope of his opinion was directly impacted by his consideration of alternative causes for Miss Lively's damages. Second, Mr. Kinrich gave a reasonable explanation for why he ruled out other causes for the decline in Blake Brown and Betty Boo's sales. He explained in his report that he was relying on the expert opinion of Professor Dina Maislin to conclude that defendants' online manipulation was the cause of the harm. According to Professor Maislin's independent analysis, by early to mid-August 2024, numerous negative comments appeared on the websites of Betty Boo's and Blake Brown products from accounts with no followers, no profile image, and no prior history. All characteristics Professor Maislin identified as consistent with sock puppet activity and astroturfing tactics. Professor Maislin concluded that this flood of negative sentiment resulting from defendants' manipulation of online conversations caused reputational spillover, and with it, measurable harm to Lively's businesses. Sales declined drastically from August 11th, 2024 to September 28th, 2024. Betty Buzz's Amazon sales decreased nearly 58%. Betty Boo's revenue plummeted from $3.4 million during its first 3 months on the market to just $1.2 million from August to December 2024, falling 70% below the brand's initial target. And Blake Brown... Oh my goodness, sorry. I hate this screen sometimes. And Blake Brown Beauty, which peaked at over $3 million during the week of August 10th, 2024, saw sales drop to $1.21 million by August 17th. This uniform decline is consistent with brand-wide disruption, not product-specific underperformance. Apart from relying on Professor Maislin's opinion, Mr. Kinrich independently investigated alternative causes by interviewing management of the Family Hive and Betty B, all of whom have confirmed there were no other plausible explanations for the steep declines in sales. Okay, so you've gone to the management of Blake Lively's own companies and they've all said, no, there's no other reason why this has happened. So we're assuming... I mean, in fairness, he's doing his job. He's got to fit a narrative here. So that's what he's doing. Okay. Critically, defendants' list of alternative causes are not alternative causes at all. Most are simply examples of defendants' online manipulation or the natural result of that manipulation. The rest are just argumentative hypotheticals based on speculation. For example, defendants criticize Mr. Kinrich for redacted and redacted. These are the very themes defendants advanced as part of their retaliation campaign. They also cite Miss Lively's redacted. Defendants also point to a generalized redacted. Far from alternative causes, Mr. Kinrich failed to consider defendants' unsubstantiated theories, provide no basis to exclude his expert opinion. Okay, so that's that. Some points, whilst I have issue with some of the stuff he's trying to testify over, I thought that actually Lively kind of rebutted Wayfarer's opposition pretty well. I do think the judge will allow him to testify. It'll be interesting to see how they treat the lack of standing argument, because I think she's got lack of standing. I don't think she should be allowed to claim for damages in her personal capacity when it's the companies that have had the losses. I'm interested to see how Lyman treats that, which should come up tomorrow, actually. But yeah, there was some things I thought that was pretty good argument. I quite like the way they argued it, even if I don't agree with it. Like, I appreciate the way they kind of argued it, especially the the new business arguments as well. I think that will survive, but we'll see. Let me know what you think in the comments. We're going to go on to the one I've been looking forward to next. I don't like this guy at all. You may have heard me say that once or twice. I tried to keep it to myself, but really, I don't like this guy at all. I think he's going to be Lively's equivalent of Dr. Spiegel at trial. So we are going on to the intimacy expert, workplace investigation expert, whatever he wants to call himself, Michael Robbins, the guy who shreds notes. We'll see you there.